So in this talk, I'm going to talk about how we can read international law as stories instead of as doctrinal law, and what that might look like. So first, however, I would like to acknowledge the fact that the traditional custodians of all of the unceded lands, skies, and waterways that Deakin and other Australian universities sit on. I personally have wrote and researched this talk on Ngunnawal and Ngambri country, and I pay my respects to all Aboriginal and Torres Strait Islander traditional custodians, elders, and ancestors whose land was stolen during colonial expansion. And I will also note that Australian Aboriginal and Torres Strait Islander communities are among the oldest continuing culture, and relevant to this talk, one that is grounded in storytelling. So, in this talk, I'm going to look at a few different things. And the first thing I'm going to start with is the social function of stories. Why do we tell stories? What do stories do for us? What is their role in society? How is this? Why are stories important? As a starting point to then look at, well, what does it mean to read law as stories, and to read it as stories instead of as doctrinal legal sources in the way that we would traditionally read things as we've been taught throughout our entire legal careers. And in reading law as stories, I kind of come to the conclusion that there are really three different types of stories being told in law. And the first of those is the idealized story in the law as written. So in treaties, in statutes, in domestic law, or what have you, conventions, all of our written law forms an idealized story. And then case law operates as two different types of stories. One of those is a story that reinterprets and updates our understanding of the idealized narrative. And the other type is a story that tells about when social reality meets the law and what happens, and it becomes the official account of those encounters with the law and contested encounters with the law. And so after I've gone through all of those, I'm kind of going to wrap up with, well, where am I going with this? Why does this matter? Why should we care about reading law as stories? So let's look at the social function of stories. And we've got some quotes here that you can have a read of in your own time. One is from Mira Grant, who is Seanan McGuire's horror and science fiction persona. That's actually a quote from one of her books. And the other is on a sociology paper that was very, good. But when we look at the social function of stories, because stories and storytelling is an inherently social activity, and stories exist to allow people to make sense of the world and their place in it at their core. That's why we have stories. That's why pretty much every cultural tradition throughout history has told stories. It allows people to make sense of the world around them. And so within this, we have this meaning-making technique. It's been present throughout all of human history and across cultures. Obviously, it looks different in different cultures, and it serves different functions in nuance across different cultures and different times of history, but the core function remains the same. This core function is one of meaning-making. And so we have some different ways that stories can be used to create meaning. So we have the option to use metaphor to make digestible, complex and abstract situations. And Lakoff uses this and advances this idea when unpacking how the US government, because he was based in the US when he was doing this, sold the populace within the US on both Iraq wars. How the US government was able to convince its people that going to war was a good thing and a necessary thing in Iraq. So that it was done through metaphor and making digestible the complexity about why they wanted to be there. We also have it used as providing context to understand normative behavior. And in a legal context, this was really well unpacked by Robert Cover in his foundational journal article, Nomos and Narrative, looking at how stories help shape our normative universe and our understanding of the normative world. But we also then see from the work of Sandberg, who's quoted, but also Paoletta and Lee, that stories are often a method of communicating truths about society. Even if they're not factual, they're about communicating truths as witnessed by people in society. So what we have in storytelling at a sociological level is a communication tool. It allows the storyteller to help the audience understand things that are outside of their experience by helping them draw parallels between reality as they know it and the experience of the storyteller. And this is a pretty consistent finding across sociology studies of storytelling. And what's important to note here is that it's inherently a relational activity. Unlike, say, the idea of reading law, where law exists in this vacuumous document where we just have the document and we only have external ideas outside of it to clarify ambiguities, storytelling puts us in a place of inherent relationality with the drafter of the document or the storyteller. And so in non-factual stories or fictional stories, this might mean that things are exaggerated to make a point. That's okay. That's pretty normal. But overall storytelling operates just to allow the audience to understand things beyond their experience and circumstances. However, and because this all sounds really inherently like good things, it's important to note that all of these ideas of storytelling are essentially amoral in nature. They can be used for good and they can be used for destructive purposes. And so we see plenty of examples about how this can operate. So we can see stories being used to advocate for better behavior in the legal profession. We can, or anywhere else, we can see stories being used to speak out against unjust governmental control. But you can also see it being used to generate propaganda on border security and immigration, on terrorism and political unrest and how governments should respond to that, justifications with wars, and to shape social perceptions about criminal behavior and who are criminals and what it means to be a criminal. And importantly, for international law, we also see that the propaganda machine that sells wars to a society follows the same narrative structure as a fairy tale. It has a villain who is overwhelming and evil and a victim. It has a hero. Sometimes the victim and the hero are the same thing. The hero faces overwhelming odds but will inherently must prevail for the good of everything, and it carries on like that. That's not what this talk is about, but I have done another one on that if it's interesting. So we have this thing where storytelling doesn't have an inherent good or inherent bad. It's an amoral, it's a technique. So the question then, what does it then mean for us to read the law as a story? And so here we have quotes from foundational articles from Francois Revold and Robert Cover talking about how law shapes society and shapes views. Francois Revold is talking about how the law creates a statistical average that is a mirror to society to allow society to understand its behavior. And cover is discussing how understanding the stories of the world can help better understand the law or what the law ought to be. And we see that in vividly one of the times I've seen that kind of relationship between law and stories that cover is talking about in some of the advocacy work of James Crawford, where he's invoked a lot of very foundational mythologies in his advocacy work to drive his point home and to do all of that. So that's all very well and good. I'm not doing that. And this is an important distinction because that's what most law and literature does. And that's very important. It's just not what I'm doing here. I'm inverting this. So it's the inverse. I am looking at, instead of how reading stories and understanding the stories about society can help us understand the law better, I am saying if we read the law as stories, we can actually better understand the societies that produced that law story. And so, same idea, but reverse approach. So, the idea that we have 2, maybe 3 types of stories in law comes from the work of Butler. So, Butler is a throwaway idea in Antigone's Claim. Makes this observation here, but before that, they made the observation that when people look at the law, that they go, but it's the law, and they're talking about the law as written and the law as that. And Butler makes the argument that what the law is in reality is the social interactions generated by the symbolic ideal that is found in the law as written. So building on that theoretical idea, I have done a lot of work building on that theoretical idea in my other work, but the basic premise I have landed at is that law as written, so the law we find in treaties, in the Charter, in the Geneva Conventions, in UNCLOS, in all of these things, they formulate an idealized notion of the law, the Platonic ideal of law. And what law in reality is the social interactions that stem from that ideal. So here I'm carrying that over to the story, to how does that change how we read the stories. And how it changes the idea is that what we then see if we read law as stories is we have an idealized narrative found in the treaty, the Charter, the Geneva Conventions, whatever we're reading, forms an idealized narrative in the same way that most cultures have a founding national or cultural mythos that is their idealized origin story and things like that. We find that story in the treaty. And then in the case law, as I said, we find 2 different types of stories. We have cases that through the judicial writing and the storytelling and they update how we ought understand the idealized narrative. And they're rarer in international law than they would be in a domestic law framework, but they still exist. And then we have cases where the judgments serve to form an official narrative of events where there was a social interaction generated by the idealized narrative and law and the ideals contained within the idealized story. So that's the general theoretical underpinning that I'm working with here, and I apologize if I've rushed through this a bit, but that's kind of where I'm working with. So now I'm going to look at what that looks like when we get to the individual types of stories, and hopefully leaving plenty of time for us to have some discussion as well afterwards, because I think that that's actually the most beneficial part of these sorts of talks for everyone. So here we've got 2 different fairly significant conventions. We have the UN Charter, a document I have spent too much time in my life reading for my sins. If anyone suggests that you go off and write a book on Article 39 of the Charter, it's a dumb idea. I've done that. It's tedious, it takes forever, and it gets really boring, and you never want to deal with the Security Council again in your life. But people keep asking you about it. So I can tell you that that's not a good idea. No, learnt from that experience. But we have in the Charter what we have here, and we can see the story. We can see it here. We, the people of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetimes has brought untold sorrow to humankind. There's a story here. This isn't just law. This is a story about how we got here, what the ideals are of this United Nations, why it exists, what its purpose is. It's a story. And if we remove it from that context, a lot of what happens after this preamble loses meaning. The idea of self-determination, or the idea of the non-interference in domestic affairs of states, or the idea of the prohibition on the use of force, or even the entire idea of the Security Council makes no sense if we lose sight of the story about how we got the United Nations that's found in the preamble. But it also then allows us to read the rest of the Charter to see what this idealized narrative about a future of peace grounded in people fulfilling their obligations and mandates in the Security Council, in the General Assembly, in all of these places. That reality hasn't come about, but there's this ideal here. There's this story of idealism about a better world found within the Charter. Similarly, we see that within the Convention on the Protection of Human Rights and Fundamental Freedoms. I'll let you kind of read that at your leisure, but that's kind of a good excerpt there. So, but to understand how we read these stories, we've also got to remember that these treaties and these things are inherently living documents. This has been endorsed at a constitutional level in Australia by numerous judges, but I'm, being an Australian who has a soft spot for Michael Kirby, I'm going to use where he dealt with it in Cheng and the Queen in 2000 at para 218, kind of highlighted that it's obvious that these documents are living texts. They're not static texts locked in time. They are constantly evolving in their understanding. And this idea about reading law as a living text that gets updated in understanding over time mirrors the literary concept of Barth's Death of the Author. The reader encounters the text in their own context and makes their meaning out of it in their own context, regardless of what the author intended. The relationship is between the text and the reader. We have that there. That's not quite how I would support that. I don't think Barth's got it quite right there, but this idea of a living document that isn't locked in time is not that controversial. But what we do see when reading these texts, not for what the law says, but for what story they tell us, is instead of seeing norms and rules, what we see is authors setting out explanations about what they're trying to address, how they're trying to address it, why they're trying to address it, and how those norms and ideas have shaped the text in front of us. So, and we can also see through that, much like Gardner's notion of exaggeration in storytelling to make a point, that the content of these treaties and other idealized texts doesn't actually necessarily reflect reality, but it's reflective of an idealized reality of the drafters, or the authors, as it were. And so we have this idealized narrative that forms treaties and other forms of legal instruments but then we also have cases. and case law that forms this idea of a narrative. And now this idea of case law forming narratives is not new. Cover discussed it as within Nomos and narrative. Dworkin speaks about judges and judicial kind of writing as a chain novel. In an international law context, Werner had a recent article on UN Security Council resolutions as a form of autobiography of the Security Council itself. I don't entirely agree with that framing because it treats the Security Council as a unitary object rather than a negotiated thing. I think it becomes more of a less minutes and more of a journaling accounting of what happened rather than an autobiography, but there's semantics there. And then in domestic law, we've also can look to L.J. Maher's work on legal wife writing that treats case judgments as a form of biography of the participants of the case. And that one I think is particularly useful as we get to point 2 on the types of cases that we deal with. So I'm trying to look here at how we can have these different cases and we can read the first sort of case to update the idealized narrative found written in the law as written, or as narrating an official iterative archive of stories about where society and reality has collided with the law and has collided in its opinions of the law. So, on the idealized narrative, for international law, I'm going to point to the oil platforms case and Nicaragua, which oil platforms was reiterating. And we have a quote there from, I think it's para 65 of the judgment. I'm sorry, I neglected to actually put that in my citation underneath it, but I think it's para 65 of the oil platform's primary judgment. And what we see here is a few different things. It's mostly we also see a reiteration of how we understand Article 51 armed attack in the most grave form of the use of force, reiterating Nicaragua, but we also see a rebuffing of the US idea of cumulative effects becoming an armed attack, noting that the US make this argument as a secondary understanding to their no gap thesis, which I think was the US take on armed attack and Article 51 is. I have a quote here from a recent article from James Krasker and Pete Pedroso, which sums it up. And I'm going to be really clear here. I've cited a lot of James Krasker's work in my work on piracy, and I was utterly disgusted by this statement of the law, and I regret having cited him now, but I can't take that back. So the quote here, and I quote, "There is also a disagreement over applicable law governing self-defense. One interpretation of international law, constructed from an elaborate scaffolding of a handful of cases animating scholarship and state interpretation, presents a narrow view of self-defense. In this perspective, self-defense is not available for low-level threats and is reserved only for grave uses of force like a major military attack. The International Court of Justice and international criminal courts have promoted this view in an effort to restrain the right of self-defense in the hope that by making self-defense more difficult to justify, war can be avoided. In doing so, these jurists have placed democracies in an untenable position by preventing them from responding to low-level threats which have a destabilizing and corrosive effect on national and regional security. The American view has always been rather more permissive, with greater leeway for sovereign states to use force in self-defense against diffuse uses of force such as gray zone operations. The United States has a bipartisan view of self-defense, which holds that any use of force constitutes an armed attack, which may trigger the right of self-defense." And I end the quote there. That's from a recent article in American Affairs. You can see here what the court's responding to is try in oil platforms, noting that this is a recent article, oil platforms was 2 decades ago, but this is a consistent US position of a hegemon on the Security Council trying to push through an understanding of the idealized narrative that is permissive of violence. And the courts are saying, no, that's not how we understand the Charter. That's not how society understands the Charter. Our official story of the Charter says we don't like war, and this is not permissive. And so that's how we have these sorts of cases updating the idealized narrative. And they're not doing that in isolation. They're doing that against arguments that are trying to create an interpretation of the living document that permits whatever they want or permits a certain set of values that are not necessarily consistent with the society that generated and keeps using those idealized narratives. So that's the idealized narrative in a very brief nutshell. And we're narrating the story of the ideal meeting reality. And the two cases I kind of want to put here is the Gabčíkovo-Nagamaros project, which anyone who's listened to Call to the Bar will know is the case that made me an international lawyer. Reading that as an undergrad is how I became an international lawyer, because I read the case in full and it took me a moment to realize the story of what had happened here, and I was just stunned. And what we have here, and it's, if you read this case purely for legal grounding, it is a judicial masterclass on defenses in international law, its state responsibility, the thresholds of necessity. It is all of those things. It is excellent at a doctrinal judicial level. This is not to diminish the work that the judges in this case did in that judgment. But we can go beyond that and we can see a story here. And we see a story here of two states who have had come into this agreement and this joint development project with the best of intentions, and circumstances have changed. Circumstances have changed in that Hungary is concerned about the environmental impacts. Czechoslovakia is no longer Czechoslovakia and is just Slovakia. And we've also then had the fall of the Soviet Union. We've had a lot of change going on, and this has led to a breakdown in communication about what to do about this joint project, which has then ended with Slovakia stealing the Danube. And they just stole the Danube, like just straight up stole it. Which is what made me go, whoa, okay, international law is really interesting. But that's the story we have here, and the judges are narrating that story and creating an official archive of what has happened here in these contested events between the two states about what actually happened here and who's right and who's wrong, before in the end getting to a point of saying, you are both wrong. You can't unilaterally stop completing your treaty obligations, and you can't take the Danube. Go home, put the river back, and sort this out like adults, is the story we have in this judgment. And that's a really different read to reading this judgment for understandings of concepts of international law, like your defenses of necessity and countermeasures, and whether or not the precautionary principle is a legal idea or soft law at the point in time. It leads to a different reading of the case. The words on the page are the same, but how you as a reader engage with it changes. Similarly, we have the MV Saiga number 2, which I picked because, I've done a lot of stuff on piracy and I like big boats and I cannot lie. And we have here a really important, from a legal point of view, case in ITLOS that sets out principles of hot pursuit. It sets out the limits of the exclusive economic zone, which was a new concept at the time of the incident. It sets out all of these things. It sets out how we can determine if there's a genuine link between a state and a vessel. It has all of those things. But when you read it as a story, what you see is a nation in Africa trying to engage in its newly expanded fisheries areas through the exclusive economic zone to engage in economic development for its people and trying to maximize that against a vessel trying to also maximize the benefit of that from the increase in fishing vessels there by supplying them with fuel offshore. And this coming into conflict, which led to Guinea opening fire with machine guns on a vessel, wounding sailors before arresting the ship. And that gets lost if you're just reading this for the law. There's a story there of that's really quite heartbreaking, of people being hurt over money because there was there was upset from Guinea that the oil bunkering being done by the MV Saiga was preventing fishing vessels from refueling import and impacting the profits they were making off their fisheries, leading to them engaging in this conduct out of a sense of desperation. It changes how we read what's there. It changes the story. And what we then have in the judgment, much like in Gabjakova Nagamaros, is we have the court providing an official version of the story, an official version of what happened here and how that came about. Because that's always going to be contested depending on who you speak to, whether or not you speak to the representatives of St. Vincent's and the Grenadines or you speak to Guinea. They brought their perspectives and the courts had to come down and say, here is what we on the evidence think happened. Here is the story as we understand it and as the official outcome of the story. So, why does this matter? And because law, like language, is a social thing. It's a social product. It's not a natural product or a natural phenomenon. And by reading Laura's stories, it changes what we understand and what we glean from these texts. It puts us in a relational situation with the drafters of the treaty or with the drafters of the court judgment. In the case of treaties and other conventions, it puts us in the position of what are these trying to achieve and what's happened that's caused them to need to try and achieve these goals and these ideals. In the case of cases that tell stories about incidences, it makes those cases human. It makes them relational, and it tells us instead about the law, still tells us about the law, but it tells us about the people that are having that social interaction driven by the law and what happened there. And, I think that gives us different insight. This is not always going to be what you need. You still need to be able to do very good doctrinal law. You need to be able to read cases and treaties for their doctrinal things. But if you read them also as stories, you will gain a different insight into what is going on in that legal text. And I can say more about what this means for legal method and storytelling, but I'm going to leave it there so we can have a conversation. I hope that's okay.